What's up, everybody, and welcome back in. We're here. The new year is starting, and we're rolling right into it with a hearing in the YNW Melly case. We've got a second trial after a hung jury that's seemingly starting to ramp up. It's supposed to be later this year, but we have a pretty big bombshell that's dropped in this hearing that might derail the entire retrial or delay it. And the judge is not going to be happy about it. And we'll listen to this hearing and listen to the defense say, hey, we found out about some of this stuff. The state didn't tell us about it. I don't know why prosecutors do that. We're going to watch this hearing, discover what that bombshell is. Spoiler alert, the defense attorney is under investigation herself, maybe with something having to do with YNW Melly, and the state didn't want to tell the defense. And the judge kind of starts out on the state side, and then you see it kind of twist in his head, and he's like, hold on a second. So we're going to watch that hearing together. We're going to discuss the retrial. We're going to see if and when it is going to happen. We're also going to answer your questions. Throw them in the chat as we go. Make sure you guys hit the like button. Let's get into it. So the part of the hearing we're going to kind of skip is when the judge reads, I feel like it's 20 motions that we have been set up and ready to hear today. And I think tomorrow they were planning on hearing a lot of these motions, tons of argument, witnesses that were going to be called, legal arguments. They've already filed the papers. The judge said, I've reviewed all of this stuff, so you don't have to repeat what's in the written documents. Let's just get to the testimony. Let's just get to the arguments you guys have that are additional here today in court. And the defense was like, not so fast, Judge. We've become aware of something that may seriously affect our ability to even represent Melly. That's a problem, right? Because we got a trial starting in a few months for the second time. It's already a new set of defense attorneys. It's a new set of prosecutors. If you remember from the last case, those prosecutors are basically all out because of at least allegedly unethical behavior. So keep that in mind when we're going through this hearing. Like when prosecutors are like, just trust us, Judge, or give us the benefit of the doubt. A lot of times with lawyers, you can do that, right? Because we have the obligation to be ethical. We can't screw it up or we could lose our license if we do something underhanded. At least that's how it's supposed to be. But it seems like depending on where you work, maybe the rules don't apply to you the same if you work for the government versus if you're a private attorney. But we've got those exact kind of issues. And this is not YSL, it's YNW. Some similar allegations and using rap lyrics and things like that. And is it a rap group? Is it a gang? Whatever it may be. Those kinds of questions are in this case, just like we're in the YSL case. But I really hope it's not the same prosecutorial antics that we saw in the first trial and throughout the YSL trial. But as we listen to this and you find out exactly what's going on, what the state knew, when they've known about this from, and how the defense found out, it's just not a good start. And the judge ends up being very upset about it. This judge, if you do recognize him, he's a new judge for the YNW Melly case compared to the first trial. It was a different judge, but he is a familiar face because this was the judge in the Scott Peterson trial down in South Florida, the Parkland shooting case resource officer that was acquitted. Mark Eiglarsh was his lawyer, came on our show, talked about that trial, talked about the case. This is that judge. Some people like this judge. He was stern. He wasn't afraid to kind of, lay into the lawyers and keep things moving. But some people thought he was too hard on the defense and didn't allow the defense to do X, Y, and Z, when in reality, potentially, because it ended up being a not guilty verdict, he protected the record, let the state do what they needed to do, only let the defense get into what was appropriate, ends up being not guilty. But he's definitely a stern judge. He's a confident judge, and he's not a judge afraid to push the lawyers to let's move this case along, and he's not afraid to make a decision. So let's take a listen to this hearing together.
So where does that put us? As I said, we've been told that the defense team of Miss Liberty is not under investigation, but we do know that there's an ongoing investigation. What we have now been...
So what he said was the rest of the defense team is not under investigation, just Miss Liberty. And if you remember, some of her mugshots came out last trial for other criminal accusations. She was the one that sat with YNW Melly basically the whole trial, talking in his ear. He was talking to her. She is still on the case. Some new lawyers have come on. Some of the same lawyers from the first trial have come on. It's kind of a mixed team. But she is not there because she got snowed in like Montana or something, which we're going to hear. But she is under investigation. The rest of the team is not. That is a big deal. And again, if it was just investigation off of, I say just assault, battery, it's a big deal. Shouldn't do it, especially if you're a lawyer. But if she was under investigation for something like that, that's totally ancillary, has nothing to do with this case. That's one thing. But is that what this is?
Working for nearly a year or over a year with the state being in possession of documents dealing with Miss Liberty. If in fact Miss Liberty has to get off the case because of the conflict that she would have, this is a year too late. We should have been informed of this a year ago. So the defense team and Miss Liberty, and therefore Mr. Demings, for a year are working on this case with the state knowing that there's the potential that Miss Liberty will be indicted or an information filed against her in the exact same case of tampering with evidence and with witnesses. And if that becomes...
So is it tampering with witnesses and evidence? Seems like the defense doesn't know, but they definitely feels like they think it has something to do with this case and that the state has known about it and they could be getting documents. They found out about this from a Google subpoena, getting information from her phone. So are they reading text messages and emails between her and the other lawyers, between her and her client? Is she going to come have to testify against her client? Is there going to be a conflict of interest? All of those questions, again, not the state's fault if there really is a crime being committed here by Miss Liberty, but what is the state's fault is they'd known about this for over a year and didn't tell the defense. The defense had to find out through other subpoenas and other ways that something is going on because the state didn't tell them. Knowing they have this active case that, Denman's been in jail for thousands of days. Melly is Denman's his real last name, but thousands of days this guy's been in jail and they're still withholding this information. It's crazy.
Case. She obviously, whether there's a conflict or not, has been waived up until that time. I think the case law is pretty clear. At that time, if she has charges against us, she has to bail out. In fact, I believe, and I'm not sure because it's federal case law, but I'd like to read to the court this paragraph from the case of U.S. versus Shagan, 661 Fed Sup 1289, 2009. In contrast to McLean, where the defense counsel was under investigation for a crime unrelated to charges against the defendant, here, defense counsel would have been under investigation for crimes that threatened the integrity and fairness of the trial. Were the government to inform the court at the eve of trial or during the course of trial that the defense team was under investigation for witness tampering, under the principles of McLean and as conceded by Cronin, the defense team would be forced to withdraw its representation of Dr. Shagan. In fact, David Marcus made the motion orally as soon as he heard about the investigation. Such a development would have deprived the defendant of a defense team that had been intimately familiar with his defense, causing him severe prejudice. And that's where we're traveling down right now. Even if we stay on the case right now, if charges are brought against Miss Liberty and they happen to fall before the end of Mr. Deming's trial, we may be forced to, under the law, to withdraw as an entire defense team.
So that's a major issue. He read the case law that if this came up during trial, the charges are filed against a member of the defense team, the entire defense team may have to withdraw in the middle of trial, which is not good for Melly. It's not good for the state because that means they're going to have to do it again. It's going to be a mistrial, waste the jury's time, the judge's time, everybody's time, all for something the state has known about for a year and should have brought it up. And were they just going to mention it on the eve of trial or during trial if they do file charges against Miss Liberty? Why do they do stuff like this? I don't get it. Why not just tell them? Why not just be open and honest and transparent? Hiding the ball does nothing. Unless you're trying to do something nefarious, obviously, which I'm not accusing them of doing and not saying they're doing. It's just usually they're like, well, it's a need to know basis and they don't need to know. It's like, actually they do. Because you're going to be trampling all over the defendant's Sixth Amendment right to a fair trial if you have yet another defense team prep for this trial, get ready, and then they have to withdraw. Now he's got to start all over. Now he's in jail sitting as a presumed innocent man, continuing to sit in jail because the state just didn't give information to the defense that was absolutely relevant and could affect his right to a fair trial, his right to competent counsel, and conflict-free counsel.
But a question still needs to be asked. Why did the state wait? Not to tell us, because they never told us. We had to find it out through Apple that there was an investigation. Because
they may have said Google, it was Apple.
A year ago, we would have sat with Mr. Demings, and he may have said, you know what, I need a new defense team. And we would have been off the case. But for a year, basically, we've been on a case that maybe we should not have been.
Okay, and another question I know I'm going to get, it's probably coming through the chat right now, is everybody knows Denman's going to stay with this defense team. He picked this defense team. It's a private defense team. He's paying them. They're getting, publicity from it. It's going to be the same defense team. Why are we doing this? He knew Liberty had, those other issues that were allegations in the past. He still decided to keep her. He's going to keep her, right? Well, you know what they say about assumptions, right? That's number one. Number two, as a lawyer, you can't live in the world of assumptions. You can't assume, no matter what your relationship is with the defendant, that they're going to be okay with it. You know what you do? You CYA. You talk to them. You have them sign something. You put it in writing, because no matter how good your relationship is and how good of a job you may be doing at trial and how happy a defendant is during trial, it can all go bad. We've seen something kind of like this in the Charlie Adelson case, right? Everything seemed fine with Rashbaum. He was representing the whole family. Everybody loved him. He did as good of a job as you could do in the Charlie Adelson trial, but he lost. And now you go back and look at what happened and you're like, haha, this was never put in writing. We all assumed they were going to waive the conflict, represent mom, represent Charlie, represent dad, whatever, family affair. But oh, no, contraire. It's not how it works. And if you don't follow the steps legally, what you have to do, it blows up in your face as a defense lawyer. So while some people, including the state, might roll their eyes, or maybe I've had state attorneys be annoyed at me when I'm saying, like, I got to stop this judge right now. My dad is great at it. He does not care if it takes 2 extra hours. If he's got to make sure every single T is crossed and every single I is dotted, be patient, do what you need to do, protect the record, argue with the judge to protect your client, take time to go talk to your client, explain it to your client. That's your job. You're constitutionally protected and guaranteed for your client because he has a guarantee to have counsel of his choice with some limitations. But you say, sorry, judge, the judge is pissed. And I think we're going to get a little bit of it. He's like, I cleared these 2 days and now you're telling me we can't do it? Defense counsel, he's clearly annoyed at defense counsel at first. And I get it. And we understand it as defense attorneys, but we still have to make sure we go tell our client. We have to make sure he understands what he's waiving. He understands that if they're pulling confidential client communications that, they're not looking at, or they have a certain team that does it, so the prosecutors aren't looking at it, Melly's got to understand that. And he's got to make a knowing and intelligent waiver and continue on with these lawyers, as opposed to saying, you know what, there's too much dirt here, there's too much smoke here, I want to switch lawyers. That's his decision and his decision alone. And while we all think he may stay with this defense team of his choice, that's his call. We're not going to make any assumptions and force them on him, because it could easily become an appellate issue later.
There are things that we need to know. We need to know who reviewed the warrant, who signed the warrant for the state as far as authorizing. We need to know whether there was a tainting. If all this information was gathered and given to the state attorneys that are prosecuting this case right now, there are
A team would be somebody other than the prosecutors that are looking at it, so that if there is something about this case, these prosecutors never see it.
Innocuous and confidential communications that will be in the hands of the state that is improper. A tainting should have been set up that reviews the documents and makes sure only those that are specific to the search warrant are looked at by the trial team. Questions need to be asked. If in fact Ms. Liberty is under investigation, then why were the subpoenas sent out, and why did that investigation begin now? And what I mean by that is there's a statute of limitations. The state was under no obligation to begin that investigation until Mr. Demons' case is over. Therefore, there is no perceived conflict. There is no conflict because we don't know that they're thinking about investigating Ms. Liberty. But instead, we were not put in that position to know that, and a year went by. If they had waited to the conclusion of Mr. Demons' case, as I said, then there is no conflict. So the only thing that I get from this is that there's the chance that within the next whatever year, or 10 months until the trial date, 9 months, whatever it is exactly, that Ms. Liberty is in fact facing charges for them. And if that occurs, then A, she can't try the case. Not sure the rest of the defense team can try the case. And don't know, and prejudice to Mr. Demons would be monumental that at this late stage you'd have to get a whole new defense team.
And one of the things he's saying is we just don't know a lot. We need to know a lot more information before anybody can really tell how we're going to move forward. And if we do have to move forward and he loses his whole defense team, judge, he didn't say this, but they're probably going to file a motion for mistrial, prosecutorial misconduct. It was their decision to do this now. They didn't wait. They could have done it sooner, could have done it later. And they're basically what the defense is ticked about is, are the prosecutors trying to just screw the defendant with the timing of this and the investigation and the charges and doing it now and not telling us, hiding the ball from us? Like, what are they doing? What game are they playing over there when a man's life is on the line?
So we need these questions answered. It's not just a simple, is there an ongoing investigation? We need to know the extent of it. We need to know the whys of when it was instituted and why didn't the state wait for this matter to be over? We need to know whether the state, if they're going to charge Ms. Liberty with this crime of tampering, do they intend to try her at the same time as Mr. Devens, or a separate trial? Obviously, at the same time, it even raises more conflict. We have a question, and that scares us. Miss Liberty has not been allowed to see Mr. Devens in person for the last, before I got on the case, for at least the last year and a half. When she goes to the jail, she must pick up the phone and use one of those phones to talk to Mr. Devens on the other side of the last partition by phone. Have they been tapped? Have they been listened into? We need to know what communications, what has gone on. So it's not just as simple as, is there an open investigation? Now, as far as going forward on these other motions that you said, we can't go forward as a defense team on any of these motions until we talk to Mr. Devens and have him understand what's going on. And for him, first of all, to make the decision. Yes, I want to keep this defense team. Yes, I want to keep Miss Liberty. Or no, I need a new defense team. We can't do anything until that's decided. I will say that after doing the research that I did over the weekend and came up with the case I cited to the board, I think all members of our defense team need to call up the Florida Bar and to see whether we're obligated, now that we know that she's under investigation, so we're obligated or not to withdraw from the case, regardless.
And that's the Florida Bar Ethics Hotline, which we call all the time. Anytime we have a question, that's what good lawyers do. It's like, hey, what do we do? And if you tell me I can stay on the case, give me a reference to the ethics rules that I can then bring to the judge or put in my file to say, hey, this is why we stayed on. They gave us this ethics rule, but they're saying maybe it's not even the judge's decision. Maybe it's not even the client's decision. Maybe according to Florida ethics, we have to withdraw from this case depending on the information we find. If they're saying that Miss Liberty is involved in the witness tampering charges that Melly has, that they're going to trial on against Melly, and are they going to try it against Miss Liberty at the same time? Are they going to be sitting there as co-defendants and she's representing it? Like, this is just a wild story. That is just feels like, again, we live in the Twilight Zone. And the fact that the state wouldn't tell them what's going on is just, it boggles my mind. Nevertheless, here we are.
Of Mr. Devens' position. So that's where we stand today. With all apologies to the court, though, I do not believe we can go forward with these motions. Mr. Devens has a lot of thinking to do. Hopefully the court will give us a hearing and some of these questions are answered, and then he can make a logical and informed decision. And by that time, we can find from the bar whether we have obligations regardless of this decision.
Rutledge says, I have to find out if there's an investigation. And the state says there is. What is your authority for all those other things that you said you want to answer? Because I didn't find any authority for that. I don't even know how I would do that. Well, if you have any authority, I understand you're saying that's this is what we like. I read what Rutledge says. That's what I'm doing right now. But you want to know about investigations. You want to know about a judge who reviewed a warrant. How would you suggest I do that? And more importantly, do you have any authority that supports any of the questions?
Well, the authority that I have, Your Honor, is the Sixth Amendment to the United States Constitution, which requires me and which allows my client to have competent counsel. And without being able to go into these things, and I also rely on the 14th Amendment due process, without being able to go into these things and have a hearing where all these things are ferreted out.
A hearing, that's what I'm asking. I don't want you to confuse some type of hearing defending this liberty. That's not really the issue. That's a yes or no question. Is she under investigation? The answer is yes. So the only other question that Rutledge requires is that Mr. Devens has to decide, does he want to go forward with her, or does he want conflict-free counsel, which I think he's certainly entitled to. And if he wants to apply that to all of his lawyers, he may do that. But that's a discussion between you and your client. I can't intervene in that. You're asking me to do fact-finding on behalf of your client so your client can make an informed decision.
Well, right. I will file another motion for a prosecutorial misconduct and ask for a hearing on that. So, witnesses in, the state will move to quash the witnesses that I would be calling in, and we'll have hearings going down.
Because they've done this again, right? They want to bring in the state attorney. They want to ask them how they did it, why they did it, what their thought was. If it's prosecutorial misconduct, file more motions. And he's like, then there's just more and more delays, Judge. I got to do what's right by my client. And nobody's happy about that, but it just is what it is.
Down that path. But this is something, no offense to this court, but I do not know how this court says that's the only thing that matters to me. There's a whole laundry list that deal with not only conflict.
That's what I'm asking. Do you have any case law?
The defense is right. The judge is like, do you have any case law that guarantees you should get all this? He's like, no, but depending on what it is, Judge, it could make a very big difference as to what my client's entitled to for him to make an informed decision. And if the prosecutors are doing this stuff purposefully to hurt him or delay the case, that's important too. They're not going to get everything, right? They're not going to get everything, but definitely more than just, is there an open investigation?
So tells me I have to do that. I'm happy to do that. You cited Rutledge, and I read Rutledge. Rutledge doesn't
I
say
have no
any of those
case law in
things.
front of me right now that says you have to do that. But I would think it would be the inherent authority of this board that you should do that. And there's certainly nothing that says you can't.
That's usually that podium that talks to me about my inherent authority, which I don't exercise. I'm happy to do whatever a statute, case law,
Well,
criminal procedure tells me to do. I don't make up things on my own.
then I ask the court, let's go one step at a time. Right now, Mr. Dennis now has been informed that his liberty is under investigation. And let us see what he decides. If he doesn't want us on the case anymore because of this, then all the things I've raised will be raised by another set of counsel. But if he does, we will be filing other motions in order so that we can get these questions answered, because Mr. Demons needs to know these before, quite candidly, he can make that choice. He can say right now that he wants this liberty, but after these facts come out, depending on what those facts are, he may decide he doesn't want this liberty or the rest of the defense team. So we'll take it one step at a time.
So your request is you want me to hear any of these today?
I don't think we can.
When would you like me to reset?
I do not know how long it will take. Miss Liberty is not in town yet right now. She's on a plane. She got snowed in Montana yesterday. Drove from Montana to Seattle. She was on an airplane ready to come here, and they canceled the flight while she was on the tarmac. She got another flight including Phoenix. She's now on a plane from Phoenix to here. Almost all these motions that you went through are Miss Liberty's motions. So A, for logistical purposes, we can't hear those motions this morning at least. We're hoping that she's back at 1:30. But I do think it takes some time for us to talk to Mr. Demons. She certainly needs to talk to Mr. Demons. So, you want to reset it for, I don't know if we can speak to him tonight sufficiently or not. You want to put it on for possible motions tomorrow with status tomorrow? You can, but I'm not sure that's enough time to talk to him.
It's not enough time, like you can't. And we need, if I may,
Yes, sir.
we need to file, based upon your Honor's comments, we need to file a motion requesting certain things about this investigation. Concerning the taint team, whether or not they relayed any of that information to the prosecutors or the investigators in this case. And I want the court to know, they didn't tell us. Apple informed Miss Liberty that a search warrant was issued on her Apple account back on December 13th, 2023. As a result of that, I contacted.
Apple tells her recently that back in December of 23, a search warrant was served on her information from her phone. So they could have gotten in the past, they could have gotten it all year when she's texting other lawyers about the case or texting, people to do with her client or witnesses, whatever it may be, calls, and they would have all that information. Now, if a taint team's looking at it, that's one thing. Totally separate team of people that are not giving it to these lawyers to see if it has to do with the crimes and not the representation. But either way, the defense team should have known about this, and Melly should have been able to decide, like, hey, if that's happening, if the cops have a warrant for my lawyer's phone in conjunction with a crime that we're accused of basically maybe committing together, I'm not really sure. Doesn't seem like they're sure exactly what's being investigated because it's ongoing and the state's not sharing that information. Melly's got a decision to make. He needs to know that information so he can make an appropriate decision on his defense team. That is obvious. I don't understand how the state doesn't see that. And you'll see it click in the judge's mind here because he's frustrated, kind of annoyed with the defense, and it kind of flips, and then he gets annoyed at the state. Like, come on.
The Broward Sheriff's Office and spoke to Christian Savanas. And I sent him a text message that said, I was just advised that Broward Sheriff's Office issued a search warrant on Miss Liberty's Apple account on December 13th, 2023, over 1 year ago. I would like to discuss this with you. He responded by saying, hi, Stu, I have zero knowledge of this search warrant or its application. Your email is the first I have heard of this. I would defer to whoever the affiant was. I don't have access to that information. I in turn contacted the state, and they said they would get back to me, which I spoke for the first time this morning to the state concerning this. I think we need to know the procedure of the so-called taint team so that any privileged communications were not relayed to the prosecution team and or its investigators. We also need to know what, since Miss Liberty represents numerous other clients, whether or not they have severed or separated those privileged communications that have nothing to do with their so-called investigation. We need to find this out
Well, do you even know the investigation has to do with his representation? That's exactly what I was just thinking, what you just said.
I assume it is since it's issued from the Broward Sheriff's Office.
How do you know it isn't related to one of our other clients or one of our other cases?
The judge is like, maybe it doesn't even have to do with this case, right? What are we all jumping the gun for? Maybe it has to do with something completely different. Maybe it has to do with a different client, right? Because we, meaning everybody sitting in this courtroom and watching this live, has no clue what's going on except for the state attorney's office, who, if you remember back and go watch some of the other videos on this trial, they don't like this defense team very much. It has not been cordial, right? They've been respectful with each other to a degree, but they have not held back on making accusations of prosecutorial misconduct, trying to bring the sitting state attorney in there to put him on the witness stand. There's been a lot of major fights, and their major argument in the trial and the defense is totally botched job, horrible investigation and prosecution of this case.
Oh,
Has
that's all I
anyone
have.
said anything that this has anything to do with Mr. Dennis?
I can't answer that without seeing the search warrant.
We're not here to make work. Does this have to do with Mr. Dennis?
It doesn't.
The judge is like, we're not here to make work. Okay. We don't need to like file more motions for no reason. The defense attorney is like, Judge, we got no clue. Nobody's telling us. And he looks at the state and she's like, yes, it does have to do with Mr. Denman's.
Search warrant.
We're not here to make work. Does this have to do with Mr. Dennis?
It doesn't.
Okay.
So can you give them a copy of the search warrant?
No, because it's a pending investigation that's still ongoing.
How does Mr. Dennis make a decision about whether?
And do you see how the judge is flipped? He's like, so it does have to do with Mr. Denman's. What are we doing? What are we doing here? He's like, can you give him the search warrant? She's like, no, Judge, it's an ongoing investigation. Because, I mean, the government does whatever the government wants, right? They sit there and say no to a judge. The judge is like, okay, well, if you're not going to give it to him, how can Mr. Denman's actually make a decision? If he has no clue what's going on, he just found out today his lawyer's being investigated side by side with him. How is he supposed to make a decision?
Pending investigation that's still ongoing.
By the way, which is why potentially they might be forced off the case. Florida Bar Ethics may be like, this is an unwaivable conflict. You guys got to get off the case. There's too much going on. If the state's not going to turn stuff over or doesn't legally have to turn stuff over, we can't take that chance. Either that or he's got to do some written waiver to where it's like, whatever it is, he doesn't care. He wants these people to be his lawyers and then move on. But something more has to happen than what's happened so far.
How does Mr. Denman make a decision about whether he wants to waive any potential conflict without having that information?
The only thing I can say, Your Honor, is again, it's a pending investigation. Knowing that she's under investigation is what Rutledge talks about. We can't get anything over until it's
Well,
officially completed.
With all due respect, but this is the due process part, the state's seeking the death penalty, the state's seeking the death penalty. So you need to turn.
He's like, all due respect, which you know what that usually means. This is a death penalty case. Due process matters. And what you're doing, investigating a witness tampering thing, fine. But this case matters. That man right there and his rights matter. His life is on the line.
The due process part.
Get anything over until it's
Well,
officially completed.
With all due respect, but this is the due process part, the state's seeking the death penalty, the state's seeking the death penalty. So you need to turn over the affidavit and the search warrant. So the lawyer.
He's like, yeah, I heard you say no because it's a pending investigation, but you're going to turn over the search warrant and the affidavit.
Can make an informed decision. All right.
It does not have to do with the homicide case.
Well, in any case, he needs to know if there is a potential conflict of interest. He's either going to make an informed, intelligent waiver of that, or she will no longer be his lawyer. And then he has to make the same decision for all of his other lawyers. And he is going to trial September the 10th, 2025.
You hear him say he is going to trial September 10th, 2025. That's 9 months away. And the judge is like, I don't want to move this. I don't want to continue it anymore. He's been waiting long enough. Turn over the stuff so he can make a decision. She's still kind of fighting with him, but he's like, we got to tell him what's going on with his lawyers. How can he make a decision as to whether or not he wants to continue? He can't even make a waiver if he doesn't have the information.
So we need to do this now. So how long will it take for you to get a copy of the affidavit and a copy of the search warrant and give it to a opposing counsel?
I'll speak with my office and you can have a week to figure this out.
Judge, they've had since December of 23. They didn't even have the courtesy to inform us of a pending investigation.
His defense lawyer is like, I know I'm winning this one, so I'm going to jump in and be like, they need another week, Judge. They've had since December of 2023. And the judge was already ticked kind of throughout that they're going to waste this time. They blocked 2 days to handle a slew of motions. And now this, And if you remember back to the trial, stuff like this happened all the time. The trial took forever because it was like every day something new would pop up that had nothing to do with even what they were doing in court that day. It was some other, circus that they had to deal with. And so now the judge is getting a little taste of that. And again, this is the tough part. Like, if you have honest, prepared, organized prosecutors, it makes everything go smoother. It usually ends in more convictions, frankly. But as a defense lawyer, it's easier to try the case because it's like, we know what's coming. We know what to expect.
We had to learn this from Apple.
But you're telling me it relates to this case.
To the tampering case.
So why would this be different than any other search warrant in any other criminal case? The defense counsel would be entitled to it.
Because she's not a subject that's been charged yet, potentially could be. It's pending investigation. All I can say is, again, pending investigation, there is a team in place, and it's still pending. So it's not like we have to handle a discovery for her. She's not a listed defendant yet.
No, but let me repeat myself.
So state's right. Like, you wouldn't have to turn over discovery to her lawyer, right? As she is if she was a defendant and had a lawyer, because they haven't filed any charges yet. So you don't have to turn over discovery, but you have an active case going on right now. And the lawyer you're investigating with the defendant, that's relevant. That's relevant a million different ways, not least of which his ability to choose counsel to have a fair trial and conflict-free, competent counsel.
It's not like we have to handle a discovery for her. She's not a listed defendant yet.
No, but let me repeat myself. Mr. Demons has to make an informed decision about who he wants as lawyers. He's now been sitting in our jail for 2,159 days. So
he's been sitting in jail, presumed innocent, whatever you think about the case, right? And if you remember back, there were some reports that it was 11-1 and the one was a holdout and just loved Melly or whatever and wasn't going to convict, whatever, it doesn't matter. He sits here procedurally and legally presumed innocent for 2,100 plus days, sitting in jail while the prosecutors are doing crap like this, which I think they should investigate things. I think they should charge everybody that they believe they can prove committed a crime, witness tampering or any other crime. There's nothing wrong with that. But just tell the defense team, hey, Ms. Liberty, we're investigating you. Here's what we have. Here's what we're looking into. Melly might want to get a different lawyer. Just do that. What do they care? Why do they care if there's a different set of lawyers on the case? I don't get it sometimes when it gets handled like this.
he's now been sitting in our jail for 2,159 days. So how long would you like to be able to make that decision?
I can't determine when the investigation will be over. That's up to the Broward Sheriff's Office, but I can.
And Melly's case is, Melly's face is like, this is crazy.
As I said, I'm just asking for a week to determine whether or not we file any sort of motion to prevent the search warrant from being handed over.
And I just can't imagine any legal grounds for that would not happen in this particular case. Is it death?
I understand that. And then I'm asking for at least a day or two.
I'm going to decide by it tomorrow. I've also reserved all of tomorrow. I took over Division FT. Judge Murphy had 44 pending first-degree murder cases. I've set them all for trial. I'm booked to trial through July of 2026. So if you all think I have 2 entire days at some point in the next 18 months to do these again, I do not. So
Understood.
I'm not sure what it is you want me to do. You don't want me to do anything else today.
He's like, I don't have 2 days from here till July of 2026. I've sent all these death penalty cases from the prior judge for trial. So we're going to waste these 2 days. Now, state, you can't tell me by tomorrow. And that's the thing that's like crazy. How can you not go back to your office and figure this out in the next hour, 2 hours, whatever, by tomorrow? It's crazy to me.
We can't under the Florida bar rules.
So do you want me to leave them on for tomorrow? You will have the balance of today to discuss all these issues with Mr. Devins. The state, you will have the balance of today to discuss some reason why you can't just turn over this affidavit.
Problem is, if they don't have the affidavit and stuff, they don't know what to talk to Mr. Demons about. They don't know what's in it. They can call the Florida bar. They can check certain things off the list, the defense team. But if they don't know all the information, Demons can't weigh his options and make a knowing, intelligent waiver.
Search warrant? I mean, it may be something immaculate. By the way, for the record, I don't know anything about this. No one brought me a search warrant. So, but maybe it's something so de minimis that Mr. Demons is going to say that's fine. If there's any conflict, I'll waive it. And, let's get to work. Or not, I guess he's going to have to go find 5 other lawyers to do this who are going to be ready to try a capital case in 9 months. So
See how the judge said that he's going to find 5 other lawyers who are ready to try a capital case in 9 months.
How about tomorrow at 9:30?
We'll be here.
Stay tomorrow at 9:30?
That's fine, Judge.
And it can't, again, I'm not taking that, but the answer can't be, my office told me X, Y, Z. Someone better be standing there with some authority that tells me they can't do it. Okay?
And he's saying it better not be, I can't give you this because X, Y, and Z. If you're not going to give it to me, somebody with some authority better be here and explain to me why they're not giving this up. So he's not saying that. I mean, they could come up with some statute or case law where they give it to him and they're like, hey, we don't have to turn this over, and fine. The judge is like, I was wrong. They don't have to turn it over. Move forward. I don't know. I guess. I don't know how that doesn't step on the defendant's right to a fair trial and right to pick his counsel. But he's like, if that happens, you better bring it. Because I'm not just going to argue with you some more or have another conversation about it or quibble about X, Y, or Z. You need to turn this stuff over so we can get a fair trial with a death penalty, a capital case. I think that's it, but I'm going to play. They do some scheduling, I think, here at the end.
Just one other thing.
Yes, sir.
You mentioned about the trial schedule, and we're obviously going to try to do it. I just want to let you know, the matters that were appealed are still up in front of the court DCA.
And they got so much going on. He's like, there's matters up on appeal. There's so many things we didn't get to hear today. Trial's supposed to happen in 9 months. We're trying to get ready for it. This humongous motions hearing we were supposed to have over the next 2 days is not going to happen because of this new explosion we got to deal with. It's just not good. And, already it feels like this ain't going to happen in September. And if it doesn't happen in September, the judge seems like he's booked till July of 26. So does that mean now we're going to September of 26? So Denman's going to sit in jail for another 365 days plus 9 months? This is crazy. Like, the wheels of justice must turn faster than this. And it's not this judge's fault. And it's not the defense team's fault. It seems like they are both trying to do everything they can to go. But you got one party not playing by the proper rules, makes things really difficult. And again, I don't fault the state for investigating Miss Liberty if they think she committed a crime, but just be open and honest and tell everybody what's going on so that everybody can plan accordingly. Or else this happens. And it just feels so unfair. But the state's got all the power, all the leverage. This is what people mean when they say they've got all the resources, they have all the power behind them, they do all the decision-making, they've got the power of law enforcement and investigators to do stuff like this and investigate your lawyer. What are you supposed to do as a private party? Right? So it is the David versus Goliath mantra at all times. And the court, the criminal justice system is supposed to be the even playing field, the level playing field. And this is why they're supposed to have to turn over that stuff. They can't just act like it doesn't exist. And good defense attorneys find out different ways when something like this happens. But I mean, it's tough. That's a tough look. I hate to see it. I really hope this thing goes smoother than the last one. I hope everything is done above board. Prosecutors, investigators, everybody, defense attorneys, even everybody, just above board. And if defense attorneys are committing crimes, they deserve to be charged and punished and convicted of crimes they're committing if they're committing crimes. They're not above the law at all. It's nothing to do with that. It's more about making sure the defendant knows what's going on because that's his right in this process. The state doesn't just get to do whatever they want and tell the defendant to sit there and wait until they tell him something. But that's all we got. Looking back into this case is really interesting. Another trial. Seems like a ton of trials are supposed to go in 2025. I promise you what I always say is they always get delayed. So all these trials we think are going to go in 2025, Adelson and Koberger and Karen Reed and YNW Melly and Corey Richens and whatever else it's going to be, I promise you multiple ones of those trials are going to get delayed from their original trial date or whatever time we think they're going to get tried at this point. So we'll see. Make sure you guys hit the like button. Let me know what case you're interested in. If you're still interested in this case, let me know in the comments. If you're not, we can move on and move on to something else. But thanks for listening. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.